right. So we get this question all the time, Dan, about, when people are buying homes, or maybe when somebody passes away, how should I hold title in my property? And, if you get something from the title company, you're going to see about 5 or 6 different forms of holding title. And we're always asked, like, which one do I choose? And I feel sometimes it's like, do you want to roll the die and pick one, or how do we come to the conclusion? But I think today, one that just came up more recent is holding title in a joint tenancy. And I know there's some obvious advantages of holding joint tenancy, but there's also some big problems with holding title in a joint tenancy, especially in a property. Do you kind of want to talk a little bit about joint tenancy, and what is it, and what are some of the pitfalls maybe versus living trust?
Sure. I think joint tenancy is probably the most popular way of holding title because it's easy to remember. Joint tenancy, 2 words, but what does it really mean? Joint tenancy is where you have more than one person on title to a piece of property. They have to be living human beings, because the last person that survives receives all the title by right of survivorship. So it's multiple people on title, all with equal share. So if you have 2 people on title, husband and wife, it's got to be 50-50. If you have 3 people, it has to be 1/3 each. If you have 8 people as joint tenants, it has to be 1/8 each. The other type of title, where you can mix up the percentages a little bit, like one could be 50 and one could be 25 and one could be 15, one could be 10, those are tenants in common. But joint tenants have to be equal. And the problem with joint tenancy is you can't control it. Title just automatically flows by right of survivorship to the surviving joint tenants. So nobody has a crystal ball. Nobody knows who's going to live longer. It's very random. And in the case of a husband and wife, for example, you could have the husband and wife on title. They each own half. One spouse dies. Title automatically goes to the survivor without probate, by the way. That's the good news.
Okay.
When the first joint tenant dies, there's no probate, as long as you have a surviving joint tenant. When the last joint tenant dies, there's no more living people on title, then it goes through probate. And that's where you need a living trust to avoid probate at that point.
Right.
But the problem with joint tenancy, as I was saying, is when one joint tenant dies, it goes to the survivor. Then the survivor can remarry somebody else, add that new spouse on title, and then when the spouse dies, it goes to another spouse, and he or she could then create a trust and leave it to their kids. And the children of the first joint tenants get completely disinherited. So that's one problem with joint tenancy, is it's uncontrollable. You just never know who's going to outlive whom. Another problem is a lot of people will add their son or daughter on title.
I hear that a lot.
Right? It's like do-it-yourself estate planning.
Right.
Hey, mom and dad, don't get a living trust.
Sign this quitclaim deed.
Sign a quitclaim deed. Add me on title as a joint tenant. Now you got son Johnny on title with, let's say, mom. Right? It was mom and dad as joint tenants. Dad dies, so by right of survivorship, title goes to mom. Mom adds Johnny. And then later what happens? Mom decides maybe she wants to sell the property and do some traveling. And what does Johnny say? Johnny says, no way, Mom. We are not selling this home because this is my future inheritance. Right. And so, no, I'm not going to sell. So that's one problem. When you add a child as a joint tenant, you lose control to that child. A third problem is liability exposure. So now mom adds Johnny on title, and Johnny goes out and Johnny gets in a car wreck, or Johnny has a business debt, or Johnny gets sued. And guess what? The creditor can now come after the entire property because Johnny owns an undivided 50% interest in each and every foot, each and every inch of the property. Johnny owns half of it, and a creditor can come force the sale of the property because Johnny had a liability. So now you have liability exposure. So you can't control it. You lose control to the person that you put on title as a joint tenant, and now you're subject to their creditors. So far it doesn't sound too great, does it?
Nope.
Another problem with joint tenancy is the tax problem. So there's this thing called the step up in cost basis, which happens when somebody dies. It's maybe the only good thing that happens when somebody dies, is that the capital gains tax-free cost basis jumps up to the fair market value as calculated on the date of death. So it doesn't matter what you paid, what mom and dad paid for the property way back when they bought it, but when one joint tenant dies, that joint tenant's 50% of the property, or if they own a third, their third of the property will step up to their proportional share of the full property. So if they own half, there will be a 50% step up in cost basis. The problem is when the surviving spouse sells, their cost basis is still low. And they'll have to pay capital gains on their 50% or their 1/3 of the gain. So joint tenancy, just to be clear, joint tenancy creates huge capital gains tax problems because it doesn't allow for a full 100% step up in cost basis when the first joint tenant dies.
Wow.
And a lot of people don't realize this. They just know when they buy a house, the realtor says, how do you want to hold title? And like you were saying, they're given a list. Let's see, joint tenancy, tenancy by the entirety. Yeah. What does that mean? Community property with right. What does that mean?
Right.
And they just go for joint tenancy because it's the easy one, but it's got all these problems.
Right. It's the first one usually too on these title forms as well.
Right.
So
the step up in basis is really a huge problem because so many people own their they own their properties for a while, and the longer they own them, the more capital gains taxes there are that are there to be paid if they sell. And if they're joint tenants, they're going to leave a big chunk of capital gains taxes on the table for the surviving joint tenants to pay if they ever sell. So a living trust is by far, I know you're going to ask me about this.
That's right.
Right, but the living trust is by far the better way to hold title because it also has that right of survivorship. It's not going to go through probate.
Right.
But you haven't added your kids on title, so they can't stop you from selling the house. You haven't added your kids on title, so you're not subject to their creditors and all of their problems. And the best thing is, if it's in a trust, there can be a full 100% step up in cost basis when the first spouse dies, instead of with joint tenancy, only a pro rata share step up in cost basis. So a trust is by far a better way to hold title than joint tenancy. Joint tenancy is kind of old fashioned. It's easy to understand, but it's fraught with problems.
Yeah, and to me, I think it's this mystery about living trust and how is it different than a will. Obviously we had some podcasts on that, but it's really interesting because the way I look at it is, let's say if I wanted to go change and deed the property to my son or my daughter, I have to go down to the county, I got to fill out some paperwork, I got to pay that, and now it becomes like very public about what I'm doing. Whereas if I have, my living trust with Modern Trust, I just go change it right now. I want to put some special instruction. I kind of feel like I can do joint tenancy, or I can, pseudo joint tenancy, or I can do whatever I want my trust, and I can change it in like 5 minutes right now. Like by the time we're talking, I can say, okay, I wanted to go with these 2 kids. This one's mean to me, and I changed my mind. I love them now. I have that flexibility, but I think that the other thing is very private. So when we're going these different forms of going to probate, public, changing title, it's public, goes from one kid to another. Even if you're just going to change from joint tenancy to another form, we had a client, they had to file the affidavit of joint tenancy, to get that done. It's just another public document. It's just another thing to do. Rather, I could just go on the app right now and get it done in about 5 minutes. So I feel like it's just cumbersome when it doesn't need to be.
Well, and there's another problem that California just created. Proposition 19 says that when you add a child or any other person on title to a house, as long as they're not living there, or any other commercial property, the county tax assessor is going to reassess the half that you just gave to your son or daughter.
Wow.
So you think in your mind, joint tenancy, I'm just going to add my kid on. It's like a do-it-yourself trust. When I die, it'll go to them. Well, not so fast, right? Because the first thing that's going to happen is the county's immediately going to reassess the property taxes on that property. And that means not only is your kid going to be paying higher property taxes, but so are you.
Yeah, makes no sense.
Yeah, and so it's better actually to just put it in a trust, and it'll go to the children in the right percentages at the right time with a fully stepped up cost basis, and your property taxes won't be affected at all at the time you create your trust. So, people get into all kinds of trouble with joint tenancy because they think they understand it, but it really is rather problematic.
And I don't feel like it's explained very well, especially like when you're buying a home. It's such like an overwhelming process, I feel like, right? You're going through, let's say you didn't pay cash, you're going through all your loan documents. Those are about 100 to 200 pages. Read the fine print. Yeah, good luck. You got all the contracts, you're dealing with escrow, you're dealing with title. And I feel like there's not a moment to like breathe and say like, or there's enough industry knowledge out there to say like, okay, hey, it's pretty simple to do. You're already in the process. How do you want to hold title? And by the way, we can actually put it in the living trust, right? Like we could do it now rather than waiting, because you're already doing that type of paperwork between the grant deed. That's what the escrow company is doing, and title and getting that recorded. And so I don't know. I kind of find a little humor in it that not in a bad way. Maybe it's satire, but it's interesting because we don't have enough time to just really think about it, Dan, and nobody's really explaining it. It's just like, and then and here's the other thing. It becomes very litigious. So when somebody will ask, the real estate broker or the lender or escrow or title, everybody's like, talk to your lawyer. And they're like, where the hell do I get one, right?
There's a lot of pressure when you're trying to close escrow on a property. You've got matters. You've got inspections for the condition of the property. You've got insurance and fire insurance that may be difficult to get in some places in California. You've got your loan and your financing and your appraisals, and you're dealing with the seller. And then, like you said, you end up with a stack of documents. And sadly, the way you take title, which is maybe one of the most important and lasting things that comes from closing escrow, is not even on the radar. It's not even discussed. And people don't know where to go to get that information. So it's kind of overlooked, and that's another reason why people just kind of default to joint tenancy, because I think they understand it. But it really should be discussed and analyzed, and maybe it should be reviewed with a lawyer.
Yeah.
So that they understand all the different ways of holding title. Of course, a living trust is very often the best way to hold title because it has many of these attributes of privacy, of avoiding probate, step up in cost basis, and it's maybe not quite so fraught with litigation that other forms of title can be.
Now, Dan, so when it comes to joint tenancy, let's just throw a hypothetical, because to me, it sounds like a no-brainer. I don't know why anybody, I don't want to offend anybody, but to me, it just sounds like joint tenancy is kind of the older way of doing things, or maybe somebody who's not really informed about a living trust. That's my personal opinion. But let's just say we have an instance where I want to do a kind of a joint tenancy type of thing. Can I set up my own trust? And let's just say I'm going to get married to somebody. They have their own trust. And then can we combine another trust? Because I think a lot of the things what I'm hearing now is I had this before I married you. And I don't want to mix that, what I had before getting into the marriage. And then it's like, okay, well, he or she has his piece of the pie. And then what do you have together? Do you have any just thoughts of this kind of hybrid? It's probably a bad terminology, but... Well,
going back to the core situation that you're describing, you own something before you were married. Now you're married. Do you want to add that spouse onto title? And if so, how? That's really the question. And, the minute you add that spouse on as a joint tenant, for example, if that's what you do, they now own half the property, whereas the property was all of yours going into the marriage. Mm-hmm. So you have to be really careful after you're married as to who you add on title. And I think the other thing you mentioned is maybe they have a trust of their own. Another hybrid option is that maybe you have your own property going into a marriage, and let's say you already have your living trust, and you marry someone and they have a few bucks of their own and they have a living trust because they were organized and responsible, and you both want to buy a property together. So what are the options? Well, one option is that each living trust could own half of the property. Not as joint tenants, by the way.
Right.
They're each going to own a percentage, and that percentage that in your trust, maybe it's 50%, will go to your beneficiaries, and her percent, your wife's percentage, your future wife's percentage, will go to her beneficiaries if she passes away. And maybe you have a life estate for the surviving spouse, so the spouse isn't kicked out onto the street if you pass away, and they have the right to live in the house for their lifetime. Maybe the trust pays the property taxes and insurance and maintenance and upkeep and so forth. But when the surviving spouse is gone, maybe the two trusts then the beneficiaries each get a respective share of the house. So there are a lot of different ways to do that, but I think the important part to keep in mind is if you're going into a marriage or you're already married and you're thinking of transmuting or combining property together or buying a new property, you definitely should think really hard about how you're going to hold title, how you're going to utilize trusts to hold title, because it's a very effective and private way to hold title, and it's a lot better than joint tenancy.
Yeah, and we have a cheat sheet if anybody needs one via Modern Trust. So there has all the different forms of ownership, and it's something that Dan and I kind of came up with. One of the things that we see for homeowners out there is the confusion. There's no document that really talks about even owning in an LLC, which I know we spoke about that, but there's different ways that you can name or put these entities there. So we have a cheat sheet for you if you'd like it, but it basically should help you out. It'll have you all the forms of title and also show you the benefits of a living trust. Dan, was there anything else you wanted to share about joint tenancy? Or I know there's a lot more, so there might be some more.
There is a lot more, maybe more next time.
Yeah, sounds good.